Welcome to the Court of History. I am Sidney Blumenthal. I'm here with my colleague, Sean Wilentz of Princeton University. The court is now in session, and don't forget to subscribe to Legal AF for all the episodes. Sean, these are incredible times. Trump yesterday openly discussed invoking the Insurrection Act, and it is past first Monday in October when the Supreme Court comes into session, and it is about to judge and issue actual opinions on at least part of what he's done. His emergency decrees that have essentially seized power from the Congress and overridden many of the federal courts.
Yeah, I mean, he's basically overthrowing the Constitution of the United States. I mean, I've been saying this for a while now that we're barely, if at all, living under the Constitution of the United States as we've known it. It's now been torn to tatters. But, you know, the Supreme Court has obviously played a major role in all of this, not just what's been going on over the last, since January 20th, but in the prelude to that. And, who bears responsibility for that? Well, certainly in the court majority. But going back, it's really a matter of looking very, very hard, I think, at the Chief Justice, who's been around longer than most, who's been behind a lot of this stuff. And many people thought as a moderate, But I remember, Sid, you may have remembered this as well, that Roberts once said, I think, that every Chief Justice of the Supreme Court, aspires to become John Marshall and will never become John Marshall, but that every Chief Justice of the Supreme Court tries to avoid becoming Roger Taney. I'm afraid that Chief Justice Roberts is certainly threatening to hit rock bottom right down there with Taney. But that's
the author of the Dred Scott decision.
Yes, the Dred Scott decision.
Yeah. So we really need to examine this because the Supreme Court has been a major player here in leading us into the post-constitutional era, which is where we are. We are now in the twilight zone. And we now have with us somebody who can offer us firsthand testimony in the court of history on this subject. It is Lisa Graves. She has written an incredible book that everyone needs to read called Without Precedent: How Chief Justice Roberts and His Accomplices Rewrote the Constitution and Dismantled Our Rights. Lisa has a lot of experience. She was the chief counsel for nominations on the Senate Judiciary Committee, working with Senator Patrick Leahy. And she was Deputy Assistant Attorney General in the Department of Justice during the Clinton administration and even into the George W. Bush administration. She's been the senior legislative strategist in national security for the ACLU. She was an adjunct law professor at George Washington University Law School. She is now the executive director of True North Research and president of the board of the Center for Media and Democracy. Welcome, Lisa.
Thank you so much, Sidney and Sean. It's an honor to be on the Court of History. Thank you for inviting me.
Yes, and your book demolishes the image of John Roberts as a mild-mannered, true moderate institutionalist. And you do so because of your own personal knowledge about encountering him and the forces behind him, beginning at his confirmation hearing. So who is John Roberts, and how did you come to understand who he is?
Well, I first encountered John Roberts when he was nominated to be a judge on the D.C. Circuit by George W. Bush in the first term of George W. Bush. And my job as the chief counsel for nominations for the Judiciary Committee was to basically vet or evaluate the nominees of President Bush, both for the courts and for U.S. attorney positions. And so I had a team working with me, but I was basically assigned myself to examine his record. And when I looked at John Roberts, what I saw was a relatively young man, given the ages typically of Supreme Court justices, who was being groomed and had groomed himself for the Supreme Court. He's someone who clerked for one of the most regressive justices in modern history, Bill Rehnquist. He's someone who worked in the first, both terms of the Reagan administration, and had a key role, not just working for that administration, but a key role in assailing civil rights laws. And then I used to joke that after he left his job as the deputy principal, basically the principal deputy in the Solicitor General's office, I used to joke that the best thing that ever happened to John Roberts was that Clinton won, so he could spend the next 8, 9, 10 years doing a little bit of pro bono work to create what I called back then a talking points resume. So if you thought he was anti-environmentalist, he'd do a pro bono case pretending to be Scalia or Rehnquist in a moot court and somehow try to gain favor with some progressive lawyers or progressive groups. But the bottom line is I thought that he was someone who was a longtime legal operative, very, very devoted to the most revolutionary parts of the Republican agenda, and that he was being chosen not to be a fair judge, but to be a player on the court, on the DC circuit, and then ultimately on the Supreme Court.
Yeah. You quote him in a speech he gave at the Reagan Library, in which he says, President Reagan never lets us forget that what we were doing was building the cathedral. So what's the cathedral that he's talking about? He is as you describe him, a deeply political person, and you call him an operative. What's the cathedral?
Well, when you think about that cathedral, I think that Reagan was talking about that, and he's paying homage to. It's a form of theocracy in America, but it's also a form of aggrandizement of presidential power. It is something that I believe to be basically contrary to the fundamental principles of our Constitution in terms of the separation of church and state, in terms of the balance of power between the three branches versus a nearly omnipotent executive branch. And when I think about it from just the legal standpoint, what I see is a mission to redefine the law in a way that repeals and reverses the gains of the 21st century, the gains of the second half, or almost the second half of the 20th century. And so really a core part of that agenda is one that is aimed at reversing the gains in civil rights.
That's right. And in particular with voting rights. I mean, voting rights seems to have been his particular dossier, right?
Yes. And in fact, the thing that was really interesting and disturbing when I looked back and looked deeply at his record was, even though when he clerked for Rehnquist, they did not handle a voting rights case that year, that was because the year before, the court had issued this case coming out of Mobile, Alabama, and that case decimated the Voting Rights Act, Section 2 of the Voting Rights Act, by saying, in essence, that the effects of a policy to change voting didn't count. You had to show intent, racist intent. And so as Roberts was clerking for Rehnquist, right across the street, Congress was working to undo that decision. And the clerks, when you look at other biographies, you see other clerks at the time talking about how aligned Roberts and Rehnquist were, particularly on the issue of race. Then it turns out two things. One part I knew, but I think a lot of people don't know, was that Rehnquist was actually one of the most anti-voting rights and anti-civil rights justices on the court. He urged his judge to vote to dissent from Brown versus Board of Education. And then as a lawyer in Phoenix, he conducted activities to intimidate Black voters in Phoenix. But that's not all. What happened next, the second part, is it was Rehnquist who called Ken Starr to get Roberts a job at the top of the Justice Department. And what was Roberts' job? Spearheading the effort to block Congress from reversing that Supreme Court precedent. Roberts had no experience in voting rights, no experience in that area of the law. The one, I guess, important experience he had was working for the justice, basically stodging for the justice who was most hostile to voting rights.
Yeah, what you describe in your book is your discovery through your personal experience of the Republican right wing's evolution into a very tight-knit clique around the takeover of the court. And, it's very much involves a small group of people. And Roberts has been part of that, and his career has been elevated as a result.
That's exactly right. There really is a pretty small clique, or there has been a pretty small clique of right wing lawyers and operatives who've been working together on election campaigns. For example, Roberts has been described as doing opposition research during the Bush Quayle campaign back in 1990 or 1988. He was someone who was called by three of the key operatives in the Bush-Cheney campaign to go down to Florida.
Yeah,
And
how
help
formative
them.
was the Florida contest that led to that came out of the Bush v. Gore decision of the Supreme Court? Who was involved? Who is now on the court, and who else was involved?
Well, that's right. Right now, with this 9-member court, 3 of the justices on the court were deployed themselves to go help George W. Bush and his team stop the recount. And that's John Roberts, Brett Kavanaugh, and Amy Coney Barrett.
Yeah. So that's a formative experience for them, isn't it?
It really is. And for Roberts, it was, basically cementing his plan to get a DC Circuit judgeship. He had been nominated by George Herbert Walker Bush back in 1992, didn't get through to confirmation. That was at the end of a presidential term. I think he was determined, in my speculation, to not be last in queue. In fact, he was first in queue. He was in the first set of people nominated by George W. Bush on May 9th, 2001, a little more than 100 days after Bush was sworn in, after Roberts and others helped him become president, as the U.S. Supreme Court, in a 5-4 decision, stopped that Florida recount and it effectively made Bush president by judicial fiat.
So helping to block Al Gore's election was a good career move on the part of the future Chief Justice, among other things.
It's a key episode in the making of the Roberts Court eventually.
It really is, because there's all sorts of ways you could speculate, but had Bush not been the incumbent in coming into that 2004 election, he might not have won election in 2004, and those vacancies could have gone to a Democratic president, could have gone to Al Gore to fill.
Yeah, I want you to step back just a bit and tell us about the important role in all this in terms of his own career and relationship with Roberts and others of Ken Starr.
Yes, so
who you worked with.
Yes, I tell the story in the book about how I went to work for Kirkland and Ellis in the summer, one of my summers in law school. And then Ken Starr ended up going to that firm after Clinton won. And the talk of the summer was how Ken Starr should have been on the Supreme Court, and how basically Clinton took that seat, that opportunity from him by becoming president. And so instead we ended up with Justice Breyer and Justice Ginsburg.
They always regarded Clinton as his election as illegitimate, as Robert Bartley, the editorial director of the Wall Street Journal, said.
When Ken Starr was then subsequently chosen to be the independent counsel to replace the previous independent counsel to investigate President Clinton, I was shocked and horrified, because I was certain that Ken Starr would do damage, would be a very damaging figure.
Why did you think that?
Because working with him, even though he was very polite and personal to me, he brought on these Thomas and Scalia clerks to work with him. Very far right wing group of people that he brought into that court, including the person who's now working for the State Department. I can't think of his name now. Christopher Landau. Christopher Landau was worked that summer alongside me, along with these other clerks, and he was right. They were very right wing, and then Ken Starr had me and some others over to his house for dinner, and he had this wall of photos with him and Bork and him and Nixon and him and every leading right-wing figure. I knew that he was a political person, not that you wouldn't have photos, but he was just someone who, despite his outer politeness, just seemed to really burn with such a devotion to the right-wing agenda. It's hard to articulate, but I found him to be someone who I would never have trusted to become a judge, and he was a judge previously that Reagan put on the court as a very young man. He was someone who, when he was Solicitor General under the George Herbert Walker Bush administration, advanced a series of extreme policies, including the gag rule over abortion and more, several anti-abortion opinions trying to reverse Roe. And Starr obviously then went on not just to damage the presidency with his investigation of Bill Clinton alongside his acolyte Brett Kavanaugh, but he also went on beyond that in his tenure in academia to have had a scandalous career there in terms of his regard for the rights of women on campus.
Yeah, he covered up a rape investigation at Baylor, where he was president. In Washington, much of the press corps at the time and elite opinion naively believed that Ken Starr was a moderate institutionalist. It's sort of the same misimpression that they have of John Roberts.
Can I address that, Sidney? Because I really think it's that they're polite in the way they speak, not the way they act, but in the way they speak. And I think it disarms people from believing the actions that they are about to take or that they've taken. That politeness, in my view, it could be sincere, but it also could be just a very political act.
My view, Lisa, is that a lot of people who were incredibly knowledgeable and central in Washington were incredibly ill-informed and ignorant about this right-wing project. And if they heard bits and pieces of it, they couldn't put it together and dismissed it. They did not understand what you describe in your book of how the court takeover took place.
Well, every single one of these characters that emerges that I see early in my career that becomes significant, later or more significant later on, it is astonishing how much criticism Hillary Clinton took for talking about a vast right-wing conspiracy, 25 years ago, when in fact there was a vast right-wing conspiracy. The vastness was, I think, in terms of just the reach of that echo chamber. In some ways, it was very small and tight, right, and was operating in a very concentrated, determined way in Washington, D.C., and getting away with an array of, what some might call hypocrisy, but just by any means necessary actions. And so
the money was vast.
The money was vast, and the ambition was vast.
You have a lot about the money and the growth of the Federalist Society and the role of Leonard Leo.
Yes. So the money was vast, and it's vaster. It's more vast now. I don't know what
we're talking about billions of dollars.
Yes, billions of dollars. So back then in the early 1980s, when the Federalist Society was launched, it was launched with the help of the Scaife fortune. That Richard Scaife, Dick Scaife fortune was built on previous fortunes. He was a sort of a half billionaire, and he was directing a lot of money to accomplishing a very far right-wing agenda. And when you think about, I guess when I think about this, what I think about it is how a very small number of right-wing billionaires have had such a grotesquely disproportionate effect on the public conversation, on the dialogue. And Scaife, was one of the early, provided some of that early seed money. And there was also early Koch money before Charles Koch and David Koch were really known for the empire of nonprofits they were creating. They had some notoriety, but they weren't really known for this. And when you look at the Federalist Society, it was launched in 1982 as a libertarian and conservative organization at the time when the biggest funders by far of the Libertarian Party were then Charles and David Koch. But that money, grew when Clinton became president. Then there was more money driven into this infrastructure, and also a media infrastructure to amplify these claims, to push these outliers.
Why did they focus on the courts and on the idea of capturing the courts? And John Roberts really is a central figure in all of this, because he is in a way, as Chief Justice, the chief strategist of what they do.
Yeah, that's a great description, Sidney. He is really the chief strategist because he has the power now to enact this agenda term by term, year by year, by judicial fiat. And I think the origins of that in part were that they wanted to capture the court. The Federalist Society wanted to capture the federal court, and Leonard Leo joined that fight pretty early on. But the beginning of that fight was led in part by Robert Bork and Antonin Scalia. They were advisors to the Federalist Society as they became judges appointed by the Reagan administration, and their objective was to reverse legal precedents they didn't like. Back in the early 1980s, that included Brown versus Board of Education. This originalist, I won't call it a doctrine. I think it's a gambit. It's a stratagem. This originalist theory was devised initially to try to take down Brown versus Board of Education, but it could then also be deployed to assail Roe versus Wade, Griswold versus Connecticut, decisions protecting the rights of the accused, and on and on and on. And so it was an attempt to capture the court in order to reverse those precedents. And the theory, I suppose, that's been put in the public is this idea that they propelled, which was that the court was a judicial activist. These were judicial activists, and they had somehow conspired to change America, when in fact the court was constituted with Earl Warren, a Republican former governor of California, put on the court. He wasn't put on the court to decide Brown versus Board of Education or reverse segregation. The judges that were on that court, that Warren court, came from both parties. They came from a wide variety of backgrounds, but they took that job of being a judge seriously, of being fair and impartial.
Yeah, you point out in your book, Lisa, that 75% of the members of the Supreme Court have been appointed by Republican presidents, although they have not held the presidency 75% of the time. And you were central in the Senate in these hearings about those nominees and other nominees on the federal bench. And there's one incident that I'd like you to talk about that really explains a lot and that involves you personally. And that is, who is Manny Miranda?
Manny Miranda was a staffer for Orrin Hatch and then for Bill Frist when Bill Frist became the Senate leader. And he took my files, took my confidential internal files, along with the files of a number of other Democratic staffers. And then he arranged for another staffer to also take those files.
Steal them.
Yes, he stole the files. He was never charged with theft. He denied that it was theft. But he did not have my consent to take those files. He did not have authorization to take those files. He stole those files. And there was a recommendation by the Senate Sergeant at Arms after an investigation that he be charged. But of course, the George W. Bush administration did not charge him. But he took those files stealthily. They were not his to take. He gave them to the Committee for Justice. He had them given to the Committee for Justice, which was C. Boyd and Gray's political operation designed to attack Democrats who dared to block or vote against Bush nominees. And we believed at the time that he also gave them to Brett Kavanaugh.
In the Bush White House.
Yes. Brett Kavanaugh had parlayed his job for Ken Starr, peddling his conspiracy theories into a role in the White House counsel's office. He was playing a leading role in the nomination process and helping to get his friend John Roberts nominated to the Supreme Court and others nominated to the Circuit Court and other judges nominated. And we believe that Brett Kavanaugh had received those files. He lied under oath 3 times before the Senate that he had not received those stolen files, even though it turned out during the confirmation hearings on his nomination to the Supreme Court that Brett Kavanaugh had received those files, including key memos of mine. And so what happened was what I used to call Watergate mission accomplished. So while the plumbers attempted to gain access to strategy documents of the Democrats by breaking into the Democratic Party headquarters at the Watergate, what Manny Miranda did was steal our strategy documents from within the Senate and deploy them to aid the outside dark money groups like C. Boyd and Gray's group and the inside campaign of the Bush White House in order to try to thwart our efforts to protect the courts from appointments like John Roberts.
And Brett Kavanaugh was right in the middle of all of that too.
Yes.
This
He was in the White
is a
House
small
as
group.
deputy staff secretary. Isn't that correct?
He was first associate White House counsel, and then by the time he was nominated to the DC circuit, he'd become the staff secretary, the deputy secretary and the staff secretary.
Yeah. So he was right there. And
yes.
So he lied under oath. He perjured.
He did. He did. I called for him to be impeached actually in September of 2018. I felt that he should be impeached, not elevated. I still believe he should be impeached. He lied under oath to Congress repeatedly.
He's not the first Supreme Court nominee who lied under oath, is he?
No, I mean, Clarence Thomas's testimony against Anita Hill was unbelievable, to say the least. There was ample evidence, ample reason to believe her. And, he lied. Then Thomas presents an additional story. Thomas sat on that Bush v. Gore case, even though his wife was actively vetting appointees to the Bush administration, and then was rewarded after Thomas cast, in essence, the deciding vote in what would have otherwise been a 4-4 ruling that would have let that Florida Supreme Court decision stand, allowing the count to go forward. After that happened, after that vote, Jenny Thomas was rewarded with the highest paid job outside the board for the Heritage Foundation and as the liaison to the Bush administration. They received more than $1 million in income over the next few years because Clarence Thomas helped George W. Bush become president of the United States. Then, when the Supreme Court was considering the Citizens United decision, Jenny Thomas worked with Cleta Mitchell to create a nonprofit to take advantage of that coming decision and received $500,000 from billionaire Harlan Crow, the Nazi memorabilia collector, as that case was pending. And then Thomas again issued the deciding vote, 5-4 decision. Had he not voted, that would have been a 4-4 decision to uphold the McCain-Feingold Act and its some related measures. And in fact, Thomas sat on that case and issued a concurrence saying it would be unconstitutional to have disclosure rules to disclose who's spending money. Of course, he doesn't want the fact that his wife got $500,000 from Harlan Crow disclosed. There's
so the corruption does not begin. The corruption did not begin with Donald Trump in this right-wing world. Donald Trump sort of made it extravaganza, but nevertheless, this has been part of the operations of this semi-Bolshevik little group that has decided to seize power. They pay each other off very, very handsomely.
Yeah, I mean the corruption is. I think we've just seen in some ways the tip of the iceberg with the corruption at the court, because we know about that trip that Alito took, Justice Alito took on Paul Singer's private jet, claiming they just happened to be going in the same direction to the same party.
Yeah,
but I doubt that that's the first private jet that Alito took. And then we saw him just 2 years ago in the midst of the scandal go and be wined and dined by one of the right-wing so-called princesses of Germany.
Yes.
So they rub elbows with these very, very wealthy billionaires, and we've seen John Roberts do nothing about it. He has done nothing to protect the integrity of the court. The idea that he's an institutionalist devoted to protecting the reputation of the court, that's just false in my view. That's a myth. That's part of the myth that Roberts has constructed. The fact is that he stood in the way of much needed ethics reform. And in fact, I think he sought to manipulate the process before the Senate by issuing a claim on the eve of a vote for subpoenas to Harlan Crow and Leonard Leo, a claim that every justice in the Supreme Court has attested that they follow basically a non-binding ethics code, including Thomas and Alito attesting that they follow it in the face of numerous investigative pieces of reporting showing how corruptly they've behaved.
Lisa and Sean, we will have to conclude part one of this conversation with Lisa Graves about her book, Without Precedent. And we will have to end it with the Harlan Crow, the collector of Nazi memorabilia and Supreme Court justices for the moment. But stay tuned on the Court of History for part two, which will begin with a discussion of how John Roberts covered up Donald Trump's coup of January 6th on the court. So for now, for the Court of History, subscribe to Legal AF. The Court of History for now is adjourned.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.